22, Rule 1A, Rule 1, Sub 1A. It reads, with your permission, a party may apply for an order, A, giving the party leave to serve on another party interrogatories relating to any matter in question between the parties. My Lord, and it is further reaffirmed by 6A of the same rule, which states a proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which took them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC. Furthermore, my lords, it is our case that if your lordships consider the questions as to NCA, there's nothing in the petitioner's case that raises that matter as an issue. Very, very well. So my lords, that
allowed to make some raise points of law to assist the court.
Yes, my lord.
We are taking this
finally.
Yes.
The final point I want to make is that counsel for the petitioner referred to Badagry JSC statement in the earlier presidential petition, but he did not quote Grill LJ, because what Grill LJ said is significant. And my lords, with your permission, I'll read from here. It is, however, the nature of fishing interrogatory trying to get, for the purpose of the defendant's case, evidence which he has not already got. On these grounds, having regard to what has frequently been decided, that because any question is a proper question to put in cross-examination, it is not therefore necessarily a proper question to put in interrogatories. We have decided that interrogatory 3 also ought to be disallowed as being a fishing interrogatory. And my lords, it is our submission that these interrogatories are indeed fishing interrogatories and should be disallowed.
May I, with your leave, just address a couple of points? My Lord, I would respectfully first observe that counsel for the first respondent in effect admits the relevance of these interrogatories, because he claims that they are dealt with in their answer. So there can't be any doubt that they are relevant. And the question whether they are in fact dealt with in the answer is the question that your lordships are going to have to decide. But he said that those matters in the interrogatories are dealt with in the answer. Now, my Lord, the second point I respectfully make is that he said that everything is in the law, and those are the steps that the EC is supposed to follow. We know that. We know what is in the law. But the interrogatories are designed to elicit what actually took place in order for your lordships to determine whether they were in accordance with the law or not. So you can't just keep telling us that everything is there in the law, everything is there in the law. We know that. But we have to establish a certain factual basis on which...
Lord, with respect, is my learned friend re-arguing?
No, this is not re-arguing a point. He is responding to the issues you raised when you quoted the
Yes, but my Lord, it will have to be on points of law, as is the tradition in the courts.
Cousin,
yes, my Lord.
Let him proceed.
And my Lord, learned counsel also referred to what Justice Adingra said. And I believe he quoted from page 71. My Lord, I respectfully draw your Lordship's attention to the fact that the decision of Justice Adingra was in respect of an application for further and better particulars. It was not the interrogatories. The interrogatories were dealt with in the decision of Justice Badegbe. And in her decision, in respect of the application for further and better particulars, her ladyship actually makes it clear she makes it quite clear that her decision is tied to the fact that there are other applications pending, including the application for the interrogatories. And basically what her ladyship was saying in the passage which I'm about to refer to is that those other applications are sufficient to take care of the matter which is being there. So that decision, which is about further and better particulars, respectfully cannot, it cannot be a basis for the submissions made. And as regards the reference to an obiter dictum of Justice Jateba, the less said about obiter dicta in this particular case, the better. I respectfully submit that far from us coming through any back door, we are actually coming through the front door of the Electoral Commission based on their own answers in order to ascertain the facts on the basis of which this court can reach a just determination.
Yes, for my edification, question 6. Question 6.
Yes, my Lord.
How does it relate to the pleadings so far filed before this court?
My Lord, counsel actually claimed that they talked about faxing. Now, all these communication systems, phones, faxes, fall within the authority of the National Communication Authority. And therefore, my Lord, a question as regards whether there was any facilitation by the national communication. I need hardly acknowledge that, I mean, the security of, communications in terms of an election process, all those matters are clearly important in the context that your lordships are faced with. So the question whether the National Communication Authority, as the institution that is legally mandated to have responsibility for communications facilities in the country by law, whether they facilitated in any way the transmission of results, my lord, is an appropriate question. Respectfully.
Mr. Chikata, this is not one of the grounds which you have stated in your petition for invoking our jurisdiction. Look at your petition. It's not one of the grounds. The mode of transmission of the results is not one of the grounds.
My lords, with the greatest respect, the mode of transmission cannot be a ground for a petition like this. The mode of transmission cannot be a ground. The mode of transmission becomes relevant in an adjudication related to what the first respondent is claiming was done. The first respondent has filed an answer and made certain claims. Now, my lord, those claims don't need to appear in our petition to be relevant. Those claims are the claims that are put in answer, and therefore issue is joined in respect of those claims that have been made in the answer. So the question that we are raising about the mode of transmission is critical, because it is a question that enables this honorable court to determine the authenticity of whatever transmission took place. That question is extremely relevant, and I believe learned counsel for the second respondent claimed that it can be asked in cross-examination and so on and so forth. But we don't need to wait for cross-examination. The purpose of dealing with it at this stage is to avoid having to go through lengthy cross-examination.
Thank you. Thank you.
The court will take a very short adjournment and come back to deliver the ruling.
All rise.
Citi TV is live. On DSTV, go to channel 363. On GoTV, access Citi TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access Citi TV on your television. Citi TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. Citi TV, it's your world.
That's kind of cynical. I mean, because I'm not sure that all that we have done have necessarily